maybe 15, 20, 25 minutes of input into this topic, and then we'll just take a few minutes at the end for any questions and answers. So Ashley, over to yourself, please. Thank you.
Thanks very much for the introduction, Kevin, and good morning, everyone. Just before we get started, I'll just share my screen, so hopefully you can see that now. Kevin, can you just confirm you can see that?
Yep, no problem. That's all good.
Perfect.
Thank you very much.
Grand. All right. Well, as Kevin said, my name's Ashley Fleming. I'm an immigration solicitor at Harper McLeod, and this morning's breakfast briefing, what we're going to focus on is an update on right to work checks, which is really an integral part of any organisation's onboarding process. So before I go in to look at the changes that have happened over the last couple of years and the ways in which you can carry out your checks, what I want to do is just give a sort of general recap on right to work checks and why we actually do them. So a right to work check is there to protect employers and also to prevent illegal working. So it should ideally be carried out before the employment commences. And this is to ensure that whoever you are looking to employ within your organisation is actually allowed to do the work in question from an immigration perspective. And provided that the check is carried out correctly, then the organisation will have a statutory excuse against any future allegation of illegal working. Now, the reasons for getting it right are quite significant, and that's because of the consequences of getting these right to work checks wrong. So a lot of you, I'm sure, will be aware of the civil penalties regime, and that basically permits the government to fine employers where they have been found to be employing individuals illegally, and that is where the individual does not have the permission to do the work in question. And the starting point for these fines is £20,000 per individual, and so they really can mount up, particularly if you're a small organisation or if there are multiple employees who don't actually have the right to work. In addition to the civil penalties regime, there is also potential criminal sanctions when it comes to illegal working, and that is where your organisation has reason to believe that the individual is not actually permitted to do the work in question. Then there is potential for criminal sanctions, which include custodial sentences up to 5 years and also unlimited fines. Aside from the sanctions and the penalties, there's also the potential for reputational damage. So there's been various occasions in the past where employers have been publicly named and shamed when they have been found to be employing people illegally. And this can happen in the press, but also the Home Office themselves publish their sort of quarterly statistics on organisations that have been found to be employing people illegally. So it's not a great look, and it doesn't, it's not a great thing to find yourselves in from a financial perspective either. So the reason for today really is to flag up some of the changes that have happened. There's been a lot of changes over the last couple of years when it comes to right to work checks. A lot of these changes were introduced initially as a result of the COVID-19 pandemic, when the Home Office introduced adjusted right to work checks back in March 2020. And that was to allow employers to continue to carry out the checks, notwithstanding the fact that a lot of organisations had moved towards a working from home model because of the pandemic. And so those adjusted checks were allowing employers to carry out the right to work check online, whereby they would view a copy of the document and then verify the identity of the individual, usually by way of a video call. So those checks ended at the end of September last year, so it's no longer possible to use that method to carry out the checks. What I would say, though, is that anyone who's carried out the checks whilst they were permitted under the COVID-19 adjustments, those checks remain valid. So it won't be necessary for organisations to redo checks that were done at a time when the COVID-19 adjusted checks were permitted. The other major change is that the Home Office has made a concerted move towards digitalising the immigration system. And so with that, they have introduced a different way of carrying out checks through their online checking system. And there's certain types of individuals with certain documentation where it is mandated to carry out an online check as opposed to a manual check where you would look at the physical document. So if you've got staff who have a biometric residence permit, for example, you checking that physical document will not comply with the current right to work check guidance, and therefore it wouldn't give you a statutory excuse against a civil penalty. So what I'm going to do now is just look at the different types of checks that are currently in use that an employer can adopt and flag up how you would carry out each of those checks. So we've got three different types of checks. We have manual checks, we have home office online checks, and then we also now have the option to use an identity service provider to carry out the checks. So you can do either one of these depending on the individual and the documentation they have. But the most important thing is that you have to carry it out in the prescribed manner to protect yourself as an organisation. So we're going to first look at manual right to work checks. Now this will be, I guess, the most common method that organisations will historically have been used to carrying out. So this is where you will obtain an original document from your potential employee, and you will have to make sure that the document that they are providing to you is approved. So it's a document that the Home Office has said they will accept as proof of the right to work. Now, there is a list of documents. There's two different lists, List A and List B, and so you'll need to check on those lists to make sure that any documentation provided is acceptable. These slides will be sent round later, and I've hyperlinked the list in the slides, so you should be able to find that easily enough. So once you've obtained the original document from your potential employee, you then need to check it. And so you're checking for the validity of the document. You're checking to make sure that the document's genuine, that it does actually belong to the potential employee. So making sure that the photograph is a true likeness, it's not an imposter that's presenting for work. And then also checking that the document does give them a right to work and do the job that you are offering to that individual. Now, when you're carrying out the check, you have to have the physical document, the original document in your possession, but the individual themselves can either be also physically present with you, or they could be on a video call. So that could happen, for example, whereby maybe they send their passport to you ahead of time and then you carry out the check on a video call. The next step after doing that is you then actually have to retain copies of the documents to show that you've carried out the right to work check and record when the check was actually carried out. Now that's a really important step, because if you do steps 1 and 2 but forget to do step 3, then you won't be able to prove to the Home Office that you've conducted a compliant check. So when you're recording the date of the check, you can either record it on the copy of the document that you've retained, but you need to specify that that is the date that the check was carried out, or you can keep a separate record of that. But you need to have these documents accessible, because if the Home Office were to visit the organisation and demand to see evidence of your staff's right to work, then you need to be able to produce those documents with ease. The other thing to note, and this applies equally to all of the different types of right to work checks that you can carry out, is you actually have to then retain the documents for the duration of the employment plus a further 2 years after the end of the employment. So that's another thing to make sure you have processes in place for doing that, and then noting when that 2 years is expired and destroying the information. The next type of check then, if we move on, is the sort of newest, or one of there's two new ones, but one of the newest models. And again, I think would probably be the most commonly used other than the manual checks. And this is the Home Office online right to work checks. So if you have an employee that's got a biometric residence permit, a biometric residence card, Frontier permit worker, or an e-visa, which are a lot more common these days, then you have to use the online checking service. You don't have to have the physical documents the same way you would do with the manual checks, which is for obvious reasons, because, for example, someone with an e-visa doesn't have any physical documentations, which for an employer, when you're used to, checking these hard copy documents, is an adjustment to get your head around. But again, the check is very similar in that you are carrying out the check and then you have to retain the evidence. And I'm going to talk you through how to actually carry out that check and just show you some of the online system so you can get an idea of what it actually looks like when you come to do it. So how it works when it comes to the online checks is that what you need from your employee is a share code. Okay, so this is something that they will be able to access from the Home Office system. They have to indicate why they're asking for a share code, because there's different types of share codes depending on what the individual needs to use it for. So they should be looking to give you a share code that begins with the letter W, which signifies work. And then also you will need to get their date of birth from them, because you will need both pieces of information in order to carry out the check. So if you can see on your screen, it just gives, this is what you will see on the Home Office website. So it says to view the right to work, go to view applicant's job, right to work details, and then you need their date of birth and their share code. And it also gives you an expiry date of the share code. So share codes are valid for 90 days, okay, and they can be used repeatedly within that 90-day period. If a potential employee gives you a code that has already expired, then you'll just need to ask them for an up-to-date code, and they can generate a new one through their system. So then when you go and put in their details, what will happen is a screen will pop up on the Home Office system, and it will present you with a photograph of the individual. It will also then give you information, and this is in this section here, about that individual's right to work. And so someone may either have the right to work, which is not time limited. So that would be someone who has, for example, indefinite leave to remain, and that is where they have permanent residence in the UK. Or you may have someone who is here with a limited right to work. So that could be a student, could be someone who's on a skilled worker visa, someone who is here on a partner visa, for example. And so they will need to have repeat right to work checks carried out prior to, well, when their visa is coming up for expiry, because you need to make sure that they've taken steps to extend their permission to be in the United Kingdom. So once you get this image up on your screen, then you have to carry out your checks. So you're looking to make sure that the photograph is a true likeness of the individual that's presenting for work. And you can do that either with them presenting physically in person at your offices, or you can also do it via video call with them. Then what you also need to do is you need to retain evidence. So this page needs to be printed, and you can see here at the bottom it says print now or download a PDF. So you can retain hard copy or an electronic copy of this record. And so again, you will keep that for the duration of their employment and 2 years thereafter the termination. So that's your online check. The next check we have, and this is again something that's relatively new. I think employers would have been using these identity services providers. I know as a law firm, we use identity service providers to verify the identity of our clients when we're carrying out our Know Your Client procedures. So there will be organisations that will already be used to using these types of systems in one way or another. But it is now possible to use identity service providers to carry out right to work checks. And that was something that was introduced last April. Although it was possible from last April, there was a bit of a slow kind of introduction, because we were waiting for more organisations to come online to offer this service. And so there's now quite a few organisations that have been certified by the Home Office to carry out the right to work checks. And so what happens is these organisations will use identification validation technology to carry out checks on the digital footprint of individuals. Now, it is only available for British and Irish citizens who hold a valid passport. So you wouldn't be able to use an IDSP for, say, for example, someone who is here with a biometric residence permit. It's only for those holding valid passports. Now, as I said, there's a list of approved identity service providers available on the Home Office website. You don't have to use one of the certified providers, but it is recommended that you do so just to make sure that their processes have been assessed by the Home Office to make sure that they're up to standard. Now, when you do this check, the identity service provider will provide you with an output or a record of the checks that they have carried out, and that should contain photographic evidence of the individual that's presenting for work. You still have to carry out a check yourself and satisfy that the photograph and the biometric information that's been provided, for example, the individual's date of birth, does match the check results that you get from the IDSP, and you want to make sure that they are consistent with the individual that's presenting for work. So again, looking to make sure that you haven't got someone who is impersonating someone else in order to begin work with your individual, with your organisation. Now again, it's all about sort of different stages of the checks being carried out. So you must again retain a clear copy of the check that's passed to you by the IDSP. And again, you have to retain that again for the same length of period that we've mentioned before. So this is a new service, but it will be of limited use because it is only for British and Irish citizens with valid passport. If you have a British citizen who presents for work with an expired passport, then you would do a manual check as your alternative to using the IDSP. The last check I want to mention is the Home Office checking service. So this is most commonly used where it's not possible to carry out one of the other checks. And that's usually because the individual that's presenting for work does need permission to work in the UK from the Home Office. They have some sort of visa, but they are perhaps in between visas. So they have made an application to the Home Office to extend their permission to be in the United Kingdom. So that would normally be where they have applied to extend their stay or switch from one visa category to the next. So they wouldn't be in possession of a biometric residence permit, for example. Now, the general rule of thumb is that someone who is here with the right to work, who makes an application to extend their stay before their leave to remain expires, will have their leave automatically extended until such time that a decision is made on their application. And that's something that's called Section 3C leave, and that's under the Immigration Act 1971. So if you have someone who is here as a skilled worker and you're extending their stay, they will be allowed to continue to work in the same job that they were initially sponsored to do in order to get that initial visa. So the conditions remain the same until such time that a decision is made. So in those circumstances, you can use the Home Office checking service to see that the individual has made an in-time application and that is pending, and you will get a result from the Home Office to say yes or no. They either have the right to work or they don't have the right to work. Now, where somebody has the right to work, the Home Office will issue a positive verification notice, and that will be valid for 6 months. So that's to give the Home Office sufficient time to make a decision on their application. If you got to the end of that 6-month period and it turned out that the application was still pending, then you would repeat the check to obtain a new positive verification notice, and that will make sure you retain that statutory excuse against illegal working. Now, the employer checking service isn't going to be needed in some instances going forward with the introduction of the Home Office's online checking service. So people that have had their checks done initially under the online system should be able now, if they've got digital e-visas, to use the online system, notwithstanding the fact they've got a pending application, and should be able to provide a share code to you. So it's always worth checking if they've got a share code first, and if not, then going down the route of the employer checking service. So that is the way, the various different manners in which you can carry out the checks. But I just want to flag up some additional points to be aware of, because you might have done all of those steps in regardless of which type of check you're carrying out, but the type of visa that the individual's on may dictate additional checks that need to be carried out. And I think the most common is students. So students, international students, when they come to the United Kingdom, may have the right to work. Not all students will have this, but typically someone who's studying at degree level will usually have the right to work for 20 hours per week during term time, and then they can work full time outside of term time. Some students will be 10 hours and some will be, they're not allowed to work at all. So when you as an employer are employing an international student who has a permission to work and it is limited in the number of hours they can do, it's not enough for you just to carry out a manual check or an online check to make sure that they have the right to work. You have to go one step further and satisfy yourself of when their term times are. So you will need to obtain the dates from their education provider to show when those term times are, so that if you are going to employ them more than 20 hours a week, you're satisfied that they're allowed to do that because it's during the university holidays, but also they need to be satisfied to ensure that they're not breaching their conditions attached to their visa, as a breach of conditions for them can mean cancellation of the visa. Now, once you check the dates from their education provider, then you need to retain that on the file as well, just the same way as you would retain the other evidence of the check being carried out, so you can present both pieces of evidence to the Home Office if required. The other category of worker is a skilled worker. Now, skilled workers are individuals who are sponsored by their employer to carry out a particular role with them. It is, however, possible for skilled workers to carry out supplementary employment in limited circumstances. So this is employment in addition to the work that they are sponsored to carry out for their employer. But in order to do that, it has to meet certain criteria. So the job or the supplementary employment that is carried out has to be in the same occupation code that they are currently sponsored for their main job. Any supplementary employment can't be for more than 20 hours a week, and it has to be carried out outside their contractual hours for their main job. In addition, the individual still needs to do the sponsored work, because if they didn't, again, that would be grounds for cancellation of their visa, because they wouldn't be complying with the conditions on which that visa was granted. So if you were to take on a skilled worker for a role, a part-time role that's doing supplementary employment, you would need to satisfy yourself that that it is a role that they're permitted to do, and generally you need to see the certificate of sponsorship and be satisfied that they are still working for their employer, because otherwise you run the risk as an organisation of not satisfying yourself that the individual has the right to work for you, and therefore open yourself up to liability for a civil penalty. So just to conclude then, a few points to flag up. So right to work checks should be carried out before someone starts, so that you're satisfied that they are permitted to do the work in question. The COVID checks and the adjustments that were made as a result of the pandemic ended towards the end of last year, so you can't carry out those types of checks anymore. biometric residence permit holders, e-visa holders, etc. You have to now use the online checks. You cannot be doing a manual check with those types of individuals. And lastly, the introduction of identity service providers for those with valid British and Irish passports is now a possibility. And that's it. Thank you very much.
Okay, Ashley, that was grand. Thank you very much for that just now. Are there any questions from our guests and from the participants? Everyone has been stunned into silence this morning, Ashley. Final call for questions. If not, I'll let everybody go and they can carry out the rest of their day. Ashley, thank you very much for that. If you can send me the slides in due
I will
course,
do. I'll send them over. Thanks very much.
And I'll send out a recording of a link to the recording of the meeting and the slides as well. So thank you very much, everybody, and have a good day. Cheers now. Take care.
Thanks. Bye.
Thank you.
Bye.
Bye. Bye.